Whenever you have a law, especially one as complex as Title VII, you'll have what we call structures, or what are the different aspects of it? Who does it apply to, especially on federal law, because of the fact that this is a big country. We got close to 400 million people living here, and a vast majority of them have some type of employment, and the law applies to all of them. So let's take a look and see exactly what structure, we talk about structure, what does that mean in the aspect of who does it apply to? So in essence, the employer cannot discriminate based on race, color, religion, or national origin. So focusing on those, because this is really primarily designed to be an employment title rather than the entire aspect of the country. So you're focusing in on a specific function. You also include gender, and that includes sexual harassment rolled into this. Pregnancy, sexual orientation is interpreted by the EEOC, and gender identity. So not as interpreted so much by EEOC, but rather the Supreme Court as well. So you're looking on the aspect of what's all involved. We need to be cautious whenever we talk about an administrative agency trying to dictate who it applies to. That is not the scope of an administrative agency. The scope of the administrative agency, in this place, the Equal Employment Opportunity Commission, is to administer the law as it is presented by Congress. Congress is the decider, not the agency, and too often we'll see, especially in days to come, we'll see that the overlap between the two of them, where agencies have assumed duties that were not delegated to them by Congress, or where Congress is actually ducking responsibility and not being specific in it, that the agency is trying to figure out what it's supposed to do. So different aspects of it, but in essence, you're looking at here is the aspect of what it covers, and we rolled in it really appropriately sexual harassment, pregnancy, sexual orientation. You have different aspects there that really covers this whole thing on the Title VII structure. It deals with compensation, benefits. Benefits are a form of compensation, classification, how you actually classify different groups of employees. We talked about that. That is a critical component in defining benefit aspects and also salary aspects as well, and other terms of employment. It deals with hiring, firing, training, discipline. It pretty much, by defining this one slide all by itself, it covers almost the entire spectrum of what it is to be involved in employment. We talk about civil rights. We talk about equal employment opportunity. If you might hire them well and have this whole process of actually going through gathering a pool of candidates and then hiring the right candidates, and you may totally fail when it comes down to training over here. This group doesn't get trained and this group does, and this group doesn't do as well and this group does. You have to pay attention and treat all employees equally, regardless of any one of the categories that you have over here of race, color, religion, gender, the actual pregnancy, and so on. You have all the different structures. This is who it's dealing with, and here are the areas that it's dealing with. This is the Title VII structure. Now let's look even deeper. It really covers places where you have 15 or more employees, each working a day, about 20 or more in the calendar. So you're dealing with a larger employer. This does not necessarily apply to the small employer. Now, the small employer had better really pay attention to this, except for the fact that the intention of the act is to make certain it's covering the larger employer and giving some more liberty and freedom with the smaller employer. It also deals with not just the employers, but labor organizations. It deals with employment agencies, people that procure workers. So you have all that going in the aspect of what's involved with the structure of itself. Employees with fewer than 15, if they're engaged in interstate commerce, in other words, between states. Okay, but no more than 15, they have to pay attention to that. Non-U.S. citizens employed outside the United States, if they're not covered by this. Also, people who are not legally able to work in the United States, it's nice. This covers them technically, but there's no way that, oh yes, we'll give this right over here, except for the fact that you can terminate them, you can do this, except for the fact that they're not supposed to be working here to begin with. So you have those kind of issues as well. Not covered also are some areas of religious institutions. Some of this is the imposition of federal law on religion, and the Supreme Court has really sat down and said, okay, You can be in charge of this area, but you cannot require this institution to have this type of benefits because that type of benefit does not apply to them as a religion. The court pays a lot of attention to this, and they really have in the last several years. This is not the activist court. In other words, the court that is making up new law that Congress didn't pass is interpreting existing law typically. So you'll always see an evolution of law, but it really goes back to stare decisis, the aspect of having a continuity of law based upon past decisions. It's interesting. If you're part of a communist organization, Title VII doesn't apply to you. Native Americans living around Native American reservations. Keep in mind, a Native American, they technically have a country within a country with their own rules and regulations. Independent contractors that are not employees, are they covered? Well, if they're working inside the organization, yes, except the contractor should be covered. So you have a gray area, but for the most part, the contractor themselves is responsible for the different rules that apply to their own employees. Claims. Here's the terminology that's used. You have a claimant, the person that is claiming there's an action that violates Title VII. There's no filing fee. Now, by the way, filing fees can be very expensive. You have the person on the other end. We call them the respondent or the responding party. Okay, they're the ones that the claimant has alleged violated Title VII. Usually it's the employer. You'll have somebody called the EEOC investigator. They review the Title VII complaints for merit. And then you have a whole series of record keeping and reporting requirements. These are the four terms that we use in defining this. Once you get involved, and I don't mean to give excuse to really a government employee, but let me tell you what they are. They are people that are required to respond to a certain protocol and process within the organization. When they show up, do not assume that they are the enemy. Assume that they're there. They can hurt you financially if you're breaking the law. They can sit there and impose different aspects of it. But for the most part, they're people coming to work on a regular basis, and they're people trying to clear out the workload that they have in the process to sit down and do that. My experience with them, I've done multiple presentations with people that are really the EEOC investigators. I used to do an annual presentation with them in talking about the compare contrast between the two. They have a job to do. Give them the tools to do their job. Listen to them. If you have a problem, fix the problem. And my experience has always been in the positive realm, although they can be pretty tough when they want to be. Pay attention to what their goal is and what their objective is. Be frank, be blunt. Try to be kind to them in the process. Always ask them out for lunch. Most of them will decline lunch and everything, but you want to develop a relationship with them and making certain that you can sit down and connect with them and find out what they're up to. Sometimes the work they do is really, truly hectic. One point I had we were talking here in California, and she says she was on her way to Hawaii because of the fact that, believe it or not, an employer was requiring employees to have sex with the owners of the company prior to being hired. I kid you not, this sometimes is how far it can become. Now, she didn't know, but she had a claimant making that charge that he was required to have sex with the two owners of the organization before they would hire him. I have no idea what the final call was, but these are the types of complaints they get sometimes. So you have the complaints from really the true mundane to the totally outrageous, and they have a job to do in investigating the complaint and doing a good job. Statute of limitations. It is a relatively brief time period. Okay, if it's a non-government employee, they have 180 days to file. If it's a government employee, 45 days to file. That's relatively quickly. But 180 days, if you think about that, is pretty much a 6-month time limitation between the time of the actual act and the filing claim. They have to respond as to what and where they're going in the process. So think about that aspect when it comes down to looking at limitations. So here's some of the things to keep in mind. It really applies to 15 or more employees. It's an employer or employment agency or a labor organization that applies to all of them. The terminology, the claimant, the respondent, the EOC investigator, and they have a large record-keeping report, they'll want to look in your files, and if they have a legal right to look at them, then you provide those to them as well, and there's 180 days to file. We call all this the structure of employment law as to how Title IX functions and works. Take care.